An overview of Employees State Insurance Act and Payment of Bonus Act. Payment of Bonus Act 1965 studied under 5 heads: purpose and scope, eligibility for bonus, key terms under the scheme, calculation and payment of bonus, and compliance with the requirements of the Act. Under purpose and scope, 3 subheads: scheme, object, and application. Very well-defined scheme under the Act imposing on the employer a statutory liability to pay annual bonus to employees. It defines the formula for payment of bonus and provides for minimum and maximum bonus with a scheme of set off and set on, and it provides for enforcement machinery for implementing the scheme. 3 unique features under the object. 1. To get the employee a statutory right to share in the profits of the employer. 2. Changing an optional voluntary gesture of employer into a statutory obligation to pay. And 3. Not an uniform bonus, but a bonus linked to profits, production and productivity. The Act is applicable to every factory under Factories Act, both private sector and public sector. It covers every other establishment employing 20 or more persons on any day during the last accounting year. And the government may notify even where the employees number is less than 20 but greater than 10 for coverage under the Act. And a factory or establishment shall continue to pay bonus even if employees number falls below minimum at a subsequent date. And in respect of a factory or establishment, every department, branch, unit are all treated as one for coverage under the Act in terms of number of employees. Under eligibility, eligible employee, disqualified employee, and exempted organizations. Employees for the purpose of Act means any person other than an apprentice engaged for hire or reward. It includes temporary workmen, part-time workers, and probationers. Even a retrenched employee who has left the organization is eligible if he has worked qualifying days while in service, and a dismissed employee reinstated with back wages also is included. In respect of seasonal factories, instead of minimum bonus, proportionate bonus is payable. To be eligible for bonus, the wage, that is basic plus DA, not to exceed rupees 21,000 per month. No bonus for first 5 years of a new establishment. However, if profit is made in any of the initial 5 years, the Act shall become applicable from the year of profit, and it stays applicable even if the establishment subsequently makes losses. The Act treats fraud and misconduct differently. An employee dismissed for fraud or theft or misappropriation or sabotage is disqualified and deprived of any bonus, and it is a case of forfeiture of bonus. But in respect of an employee guilty of misconduct causing financial loss to the employer, the Act provides for deduction of the loss from the bonus of that accounting year and payment of balance, if any, to the employee. 3 key terms: rate of bonus, days worked, and adjustment for ex gratia. The rate of statutory minimum bonus is 8.33% of basic plus dearness allowance. The minimum bonus is payable to all employees of age 15 years and above and eligible for bonus, irrespective of availability of profits. Of course, bonus is not payable in respect of new establishments for the first 5 years subject to terms. Maximum bonus is attracted when the allocable surplus exceeds the amount of minimum bonus. The employer in such a case will pay bonus up to 20% of lower of rupees 7,000 or actual wages. For example, if the salary is 18,000, maximum permissible annual bonus will be 20% of 7,000 into 12 months equals 16,800. And the bonus other than minimum bonus will be distributed in the ratio of salary and wages received during the relevant accounting year. To be eligible for bonus, an employee should have worked for not less than 30 days in the year, including layoff under Industrial Disputes Act, paid leave availed, maternity leave, and absence due to temporary disablement. Where an employer pays puja bonus, interim bonus, or any other ex gratia as bonus, he is entitled to recover the same and pay the balance bonus to the employee. Under calculation and payment, calculation of available surplus, allocable surplus, set on and set off, and the timeline for payment of bonus. The calculation starts with net profit before depreciation and tax as per the profit and loss account. Available surplus for any accounting year shall be after deducting the following items: depreciation under Income Tax Act, development rebate or investment allowance under the Act of Income Tax, and any direct tax the establishment or the factory is liable to pay on its income, profits and gains for that year. Deduction will also be made for sums specified in the third schedule to the Act, that is, actual dividends payable on the preference share capital for the year, and on the opening balance of paid up equity shares, a provision of 8.5%, and similarly on the opening balance of reserves as per balance sheet to be provided for at 6%. The available surplus as calculated after the deductions is applied a factor of 60% in respect of a local company and 67% in case of a foreign company, and the resulting figure is known as allocable surplus, which goes into payment of bonus. Any calculation of the amount of bonus will be after considering the carry forward from the earlier accounting year for set on or set off. If the allocable surplus for any year is not sufficient for payment of minimum bonus, such deficit will be carried forward being set off, and it can be set off up to and including the fourth accounting year. If the allocable surplus exceeds the amount of minimum bonus, the bonus will be paid in proportion to salary or wages earned by the employees during the accounting year, subject to a maximum of 20% of lower of 7,000 or such salary or wages. If the allocable surplus exceeds the maximum bonus payable, such excess can be carried forward for set on in the subsequent accounting year up to fourth accounting year. Key provisions on compliance: employer obligations, inspector, contracting out, and claims and recovery. Bonus is required to be paid within 8 months from the close of the accounting year. Supposing the financial year ends in March, payment needs to be made by end of ensuing November. If the bonus is subject to an industrial dispute, then it has to be paid within a month of the award becoming enforceable. An employer under the Act is obliged to maintain the prescribed registers to calculate and pay the annual bonus as required under the Act, to file annual returns in respect of bonus paid, and to afford an inspector under the Act all reasonable facilities for making any entry, inspection, supervision, examination or enquiry at the establishment or plant. The inspectors appointed by the appropriate government are empowered to examine and inquire whether the provisions of the Act are duly observed, to enter, inspect and search premises, to require by written order production of registers, records and information, and to take copies of records, registers and documents related to any offence. The Act prohibits contracting out. All agreements inconsistent with the provisions of the Act are inoperative. Any agreement where an employee relinquishes right for statutory bonus shall be null and void. Any dispute between an employer and his employees with respect to bonus payable is deemed to be an industrial dispute within the meaning of the Industrial Disputes Act 1947. Where an employer has not paid under a settlement or an award or agreement, the employee or anyone authorized by him or assignee or legal heir in case of death may apply to appropriate government within 1 year from the date money became due, and the appropriate government or authority, if satisfied, may issue a certificate to the collector to recover the dues as an arrear of land revenue. Payment of Bonus Act, purpose and scope, eligibility, key terms, calculation and payment, and compliance terms. Progress review of Payment of Bonus Act. Bonus is an incentive to improve productivity and production. It is not a deferred payment, nor is it a gratuitous payment. It is a regular statutory payment. For eligibility for bonus, the maximum salary limit is 21,000. The salary or wages under Bonus Act comprises mainly basic and DA and also city compensatory allowance. Bonus is always paid for an accounting year. During that accounting year, an employee has to work for a minimum of 30 days, and that fulfills the eligibility. There is a minimum for the bonus to be paid once a person becomes eligible. The minimum is 8.33% of the salary or wage earned by the employee during the accounting year, or a minimum of rupees 100, whichever is high. The Act provides for maximum bonus also. Maximum bonus is 20% of the salary earned during the accounting year. There is a ceiling in between. Though the eligibility requires salary within 21,000, any salary which is earned above 7,000 rupees is considered as equivalent to 7,000 only. Means bonus is calculated on the maximum amount of 7,000, although 21,000 is the amount for eligibility. The salary or wage where it exceeds 7,000 per month, the minimum or maximum bonus payable is calculated as if the salary or wage were 7,000 per month. The bonus has to be paid within 8 months of the closure of the accounting year, and where the employer has paid some temporary or ad hoc bonus like customary bonus to an employee, at the end of the year when he calculates bonus under the Payment of Bonus Act, he can adjust for or recover that amount from the annual bonus. There are two situations where an employee is prevented from getting bonus. One, he is disqualified if there is a case of dismissal for fraud, violent behavior, theft, misappropriation or sabotage to any property of the company, means where he is dismissed. Number two, where in any accounting year an employee has caused financial loss. He might not have been dismissed, but he has caused financial loss to the employer. The employer can recover or deduct that amount from the amount of his bonus for the year. Based on a court order, whenever a dismissed employee is reinstated with back wages, he is entitled to bonus for the period. For the first 5 years, a new undertaking is exempt from payment of bonus. However, if there is a profit during these 5 years, in that particular year where there is profit, bonus has to be paid. Any dispute between employer and employee as regards payment of bonus is considered as an industrial dispute. Whenever there is a court order or whenever there is an award by a relevant authority, the payment of bonus as ordered by that authority has to be made within 1 month of the award. Any case taken to the court will be accepted by the court only where the complaint is made by the appropriate authority or under the support of that authority who is authorized by the appropriate government. There is an annual return for payment of bonus filed under Form D. It has to be filed within 30 days after the expiry of the time limit for making bonus payment. Time limit is 8 months after the accounting year is over. Bonus Act is not applicable to government departments and specifically Life Insurance Corporation. Establishments in the private sector and establishments in the public sector are the two classifications made under Payment of Bonus Act for its application of provisions. An establishment in the public sector is owned, controlled or managed by a government company. While calculating bonus, it is permitted to deduct from the gross profit three items in specific: depreciation, development rebate, and any direct tax payable. This is for the calculation of bonus. Similarly, in respect of banking companies, while calculating the bonus, they are allowed to make an additional deduction of 7.5% of the paid up equity which was there at the commencement of the accounting year out of the gross profit in computing the bonus. And in case of non-banking companies, 6% of the reserves at the commencement of the accounting year is allowed as a reduction from the gross profit in computing bonus under the Act.